Hello everyone, welcome back to our channel. Good morning, good afternoon, good evening. I greet you all according to your time and locations you'll be watching this video. Yes, my dear viewers, I am back again with another update. So guys, I have a video here I would like we all to watch. But before then, if you're meeting my channel for the very first time, you're highly welcome. Please kindly do well to like, share and subscribe. Leave your thought on the comment section and let us know what you think about this video. And I will see you towards the end.
But we know that the executive has had review of their salaries. The legislature, we hear that they receive millions of naira at the end of every month. But that is not what you hear about the judiciary. Would it surprise you to know that a justice of the Supreme Court received just about 702 or 750,000 naira monthly?
One of the things we discuss often on the show is how important the judiciary is for us to actually have a sustained democracy. One of the issues we've had in Nigeria is that corruption cannot be totally defeated if our judicial system is not effective and people are not probably convicted for the crimes they commit. One of the major issues that many would say the new AGF or even you would have to do right now is the fact that many cases are stalled for years for various reasons, technicalities, maybe they keep postponing the date. What do you think can be done to strengthen the current judicial system as it is today?
Well, thank you very much for that question. And let me make the point from the very onset that the responsibility of anyone that has been given the task to prosecute any criminal matter is not to achieve conviction at all costs. Because the prosecutor equally has the responsibility where he discovers in the course of his investigation that the person against whom a crime is alleged, there are facts that can help him in his defense. That prosecutor is under a duty to make those facts available to the defense for the defendant to use it for the purpose of his defense. So it's important to make it very clear that the objective is not to secure conviction. It is to pass through the process set by law for the purpose of determining the justice of that case at that particular time. And so, in that particular process, before the matter comes to court, a lot of things would have happened from the point of investigation, the collection of evidence, the advice that is given, and then the matter or the charge is filed before the court, and evidence is led by witnesses before the court. Now, the judge is under strict obligation to confine himself to the matters that are presented before the court. And when those facts are presented in terms of evidence, the responsibility of the court is to look at the nature of that offense. What are the ingredients of that particular offense? Has the prosecution satisfied the ingredients of those of that particular offense? So that, and so it could be said that the offense has been proved beyond reasonable doubt, and only then can a pronouncement of conviction be made.
Okay.
So when the public sees the outcome of any proceedings from the court, the public must know that, number one, irrespective of what you know out there about what happened, the circumstances that led to the commission of that offense, it is only the things that are brought to the knowledge of the court in the case that will form the basis of the determination that the court would make one way or the other.
All right.
Great. So let's talk about financial autonomy. The judiciary literally depends on the executive for funding. So help us understand how this lack of financial autonomy is affecting transparency and the true independence of the judiciary.
Well, we all know, we need resources to drive any process of governance. The legislature will need resources for it to function effectively and efficiently. The executive does also require resources for it to operate within the ambit of what the Constitution has prescribed for it to do. Similarly, the judiciary also requires resources for it to function within the ambit of what the Constitution has prescribed for the judiciary to do, in terms of the structures that have to be put in place, in terms of the development of the capacity of the judges and other workers that support the administration of justice and all. And so resources are very important. Funding is very important, and the autonomy of that funding is also important. But a situation where the judiciary would have to go cap in hand, begging for resources in order to perform its own constitutional responsibility, certainly impairs on the independence of the judiciary. And where you find someone who does not respect the independence of the judiciary in the executive, then such a person will begin to manipulate the process and use the fact that I have to give you this fund for you to do what you are supposed to do to bargain with the judiciary. And that is why the judiciary has insisted that for us to function properly, don't pauperize us.
All right.
But it will seem to me that over the years, that is what has been done. To know that the judiciary, the last time that the salaries and allowances of judges and justices in this country were reviewed was in 2007.
Wow.
Notwithstanding the inflation, notwithstanding the concrete economic realities. And if it isn't to pauperize the judiciary so that you render them incapable of performing their responsibility, then I wonder what that is.
Right.
But we know that the executive has had review of their salaries. The legislature, we hear that they receive millions of naira at the end of every month, but that is not what you hear about the judiciary. Would it surprise you to know that a justice of the Supreme Court received just about 702 or 750,000 naira monthly as his salary with the workload that is in the Supreme Court? And to know that it is the judiciary, whether you like it or not, that is the truth. It is the judiciary that has kept this country together by reason of their pronouncement over the disputes that we have seen.
Yeah. All right.
Since independence.
Let me get a few more questions.
So there is a deliberate attempt to pauperize the judiciary over the years, and that is why the judiciary has been denied its own financial independence. But I must salute the courage of the judiciary for standing up to the situation in spite of that. And you remember the last administration came up with Executive Order number 10, and that became a subject of litigation before the Supreme Court. And the Supreme Court struck it down to say that, yes, we know that we've been denied the resources that we require to function properly. But if you have to give us resources, if you have to fund the judiciary, you have to do it properly. That is a demonstration of discipline. Even though they've been pauperized, they've been rendered incapable of performing their responsibility. But the Supreme Court demonstrated responsibility. They demonstrated discipline.
Right.
You don't just come and, as it were, maybe rub a little bit of oil on our lips with Executive Order 10 that we should be giving this amount of money, while doing so also breaches the Constitution. The Supreme Court said no. It seemed to us that this is made to benefit us, but we will simply stay with our oath to defend the Constitution of this country.
All right, go ahead.
So I thank the judiciary for doing all of that.
All right.
And remaining resolute in the performance of its own responsibility in spite of the conspiracy, I should say, to pauperize the judiciary.
All right.
Okay, sir. There's something that I see often and has bothered me, in past administrations, and I think,
even very recently, which is the judiciary would give an order, either bail conditions or ask someone to be released, and then we have executive agencies who seem to have superiority over the judiciary. Case in point, we have situations with DSS. Somehow DSS seem to have superiority over judiciary. And I wonder, as the MBA, how this is being addressed and whose fault is it? Is it that the judiciary itself has weakened itself because of corruption? Is it that the judiciary is not strong enough to demand that, you know, the rule of law be followed? How are you even addressing it?
Well, let me correct the impression here. There is no institution that is above the judiciary. Not the DSS, not any institution that is above the judiciary. And also, let me make the point. The most uncivilized thing that any person or any organ of government would do is to show disrespect to the orders of court. Because doing so is an invitation to chaos and to anarchy. And I want to repeat, that is the most uncivilized thing that anybody would do. But let us not forget that there are processes. There are processes. And those processes must be complied with within the ambit of what the law has provided. And for every case you see, it is important for us to have a holistic view before we can pass any assessment or judgment on the conduct of any particular agency. And so questions have been asked, particularly with respect to the issue of the DSS vis-a-vis the MFLA matter. I know that matter is in court, even though that particular charge has been withdrawn, where the issue between the DSS and the officers of the correctional facility happened in Lagos. But let me say that none of these organs is bigger than the judiciary, and all of them are subject to the orders of the court, which must be obeyed at all times. And every single one of us, including the institutions, have a constitutional duty to comply and enforce the order of court.
Okay.
What is the NBA doing? The NBA consistently engages with these institutions to let them know that you cannot show disrespect to the processes of court, disrespect to the order of court, and expect that we would have order in the society.
Right. Okay.
Right.
Let me.
So,
Sorry, because of time, we have so many questions for you. So I wanted to get a few more questions for you before you run off. There's this long-standing debate, and I'd like to hear your stand or NBA stance on it between the role of the Attorney General of Federation and the Minister of Justice. There's always that clash we've heard for over the years. What's the position of the NBA on this? So you're going to answer my question now. Go ahead, please.
yes, would you permit me to correct the way you pronounce that name?
Mike Yao.
Mikel.
It's
Mikel.
Yakubu Chonoko Mikel.
Mike Yao. All right. I do apologize.
Yes. No, it's all right. I mean, I get this most of the time. So you are asking about the position of the Nigerian Bar Association on the merger of the office of the Attorney General and the Minister of Justice.
Yes.
For us, it is about getting the right person in the office, someone who appreciates the responsibilities trusted on him by the Constitution to function in that particular office, completely separated from the politics that is involved. Yes, agreed. It's the president that appoints such a person into office to function, but such a person must understand that of all the ministers in the cabinet, he is one that enjoys constitutional prescription, meaning he's the only person that has been mentioned in the Constitution of the Federal Republic of Nigeria. And so such a person must bring to bear that understanding in the office and know that all that must motivate his conduct in that office is the desire to do justice. As Attorney General and then Minister, is the chief